No one likes the thought of a marriage ending, and when it comes time to divide and distribute possessions, it can get pretty uncomfortable. Statistically, 1 in 4 people who get divorced are age 50 or older. Regardless of whether or not your divorce is amicable, your spouse as well as any dependents are entitled to a portion of your assets. Particularly with a 401k distribution, understanding how the process works and what to expect can make a difficult and uncomfortable situation easier and less stressful. I'm Josh Kadish, partner at RPG Life Transition Specialists. We get asked all the time about what happens to retirement accounts in a divorce, so I'm going to take a few minutes to address some of the top questions we get asked. So here we go. Let's say your marriage comes to an end and you and your spouse have a 401k or retirement plan. How do you know if your spouse is entitled to any of your retirement accounts? First, your divorce settlement agreement will specify exactly who gets what in the divorce. Beyond that, the court handles 401k divorce distribution by issuing a Qualified Domestic Relations Order, or QDRO, to outline the specifics of dividing the retirement plan account. The QDRO essentially establishes a former spouse's right to a portion of an ex's retirement benefits and is used frequently to determine alimony, child support, and property rights payments. A qualified attorney can help protect the funds in a 401k by ensuring the QDRO is accurate, valid, and acceptable under the law. We normally get asked a lot of questions about taxes and what to expect to have to pay. While the spouse distributing the money from a 401k will not be subject to early withdrawal penalties, the receiving spouse will owe taxes unless the funds are rolled over into a qualified retirement plan. Drafting the QDRO can be time-consuming and difficult, which is why it's essential to thoroughly understand the plan administrator's guidelines and use a skilled professional to get the job done quickly and efficiently. Another question we get is, what determines how the funds are divided from a 401k in a divorce settlement? Typically, the individual states determine how the funds in a 401k are divided. In most cases, divorce settlements follow equitable distribution, meaning that 401k assets accumulating during the marriage are divided in half. But it's generally not that simple. There are other important variables to consider, including the length of time and to what extent both you and your spouse contributed to the marriage. Currently, there are 9 states: Texas, Arizona, California, Utah, Nevada, Idaho, Louisiana, Washington, and Wisconsin that consider accrued or invested retirement benefits community property. In these states, a 401k is typically divided 50-50 regardless of any additional marital assets. To continue on the division of assets, there are basically 2 different methods for dividing the funds from a 401k. You can conduct a present-day valuation buyout or divide the funds into 2 separate accounts. Splitting the funds into 2 separate accounts simplifies the division process and in most cases allows you to continue to manage and contribute to the account as before. Understanding a divorce settlement and how a 401k is divided can be confusing. It's important to know that a former spouse and any dependents are entitled to a portion of the assets. Consider using the skills and expertise of a professional to help educate you and ensure assets are divided properly, reasonably, and in a timely manner.